This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Put your questions in the comments, but before we start, let's give out those free consultations. I'm going to wait for some more viewers to come in, some more people to join us, and then I'm going to say the code word. So you can only call and get the free consultation with the code word. So make sure you have the code before you call. Otherwise, you're not going to be able to get that free consultation. Now, let me just quickly explain the rules here. So the first two people who call will get the free consultation as long as they give that code. Now, there are only two staff members who are authorized to give these free consultations. So if you talk to anybody else, so it's Jalen and Eleanor. If you talk to anybody else, then it's very likely you did not get through to the two authorized staff members who will handle those two free consultations. Go ahead and dial this number in. So it's 561-405-4889. So it's going along the screen on YouTube, on Facebook, on Twitch, then on TikTok is at the top of the screen. If you scroll up the columns, the comments, and on Instagram, I'm going to say the number again. It's 561-405-4889, and the code word is unity. So go ahead and say unity for the free consultation, and you'll go ahead and get it. Call now. Go ahead, call now. I already gave you the number 561-405-4889, and the code word is unity. When you go ahead and give them that information, then and you get the two staff members authorized to give the free consultations, you will be scheduled for your appointment. So congratulations to whoever gets that free consultation now. So yes, are you taking consultations right now? So not in this moment. All the consultations are scheduled because I don't do any surface level consultations. The consultations I do are very detailed, and so we do need a dedicated scheduled time to do the appointment. All right. So now I excuse me. I have a topic that I think will be of interest to you, and it's a question that comes up very often in the consultations. So it can possibly save you some time if you're listening to this. You'll get the right information to let you know what direction you need to go in, and that's it. Is you've overstayed. Do you qualify to have an employer sponsor you? Now, if you have already overstayed, it is very unlikely that an employer is going to be able to fix that situation for you. And that's because under employment immigration, they're very strict about about an employer petitioning for an employee who does not have their current status, and that, of course, that employee wants to stay here to apply for the green card. They will not be able to go through adjustment of status if they have overstayed and the employer wants to petition for them to overstay. Another big concern here is sometimes I'll hear that the employer has been proposing that they petition for the immigrant when they're already working for them. Some of them have already been working for them for a year. And so that's another thing, is if you have been found to be working without a permit for that length of time, they are not going to allow you. They're not going to approve that adjustment of status for you. So you will not be able to proceed to get your green card in the United States through an employer if you've already overstayed. Now there are two exceptions, and even with one of the exceptions, you're not allowed to stay here just for part of the process. But there is an exception here. If you fall under what's called Section 245I, it's a special law. So some people even refer to it as an amnesty law, where if you were here or you were filed for on or before April 30th, 2001, then even if that wasn't approved at the time, it was approvable, but for one reason or the other, it just didn't go through. Then it means that you could fall under an exception where you could stay and apply for your green card through the employer. Nobody has to go home, and you can go through the process that way. So if you want to see if you qualify for Section 245I, if you remember that you were on a filing in the past, and in the past, when I say in the past, before 2001, so on or before April 30th, 2001, that would be a good way to start to see if you still qualify for an employer to petition for you while you stay here in the United States. So that is an exception. Otherwise, and I see here, Mia is saying here, this is good info. Some people are scamming people. Yes, that is happening. So there are even employers that are promising. Employers are so desperate for employees to come work for them that they are also luring people to work for them using the promise of sponsorship. And in some cases, the employer knows that they cannot sponsor them, but they use it as a fraudulent way to get the person to work for them. So the general rule here is you cannot be working for the employer first and then get the green card after. So if the employer is saying, work for me for a year and I'll get your green card for you, false. That's not allowed. The employer is supposed to get you the work, at least the work permit first. And when I say get you the work permit, you'd have to apply for adjustment of status to get your work permit, and then you can start working for the employer. But anything before that, that employer is not telling the truth. They cannot get you any kind of sponsorship after you work for them. It always has to be before. And then, you also have to look out for those employers. They might be well meaning, and they might, tell you that if you come work for them, they'll look into sponsoring you. They may truly not understand that they don't qualify to apply for you at that point, or you don't qualify because of an overstay, or you don't have your papers. So it's up to you then to use your judgment and identify this. So don't fall for it. The rule of thumb here is you get the papers first, then you work for them. If they're proposing anything other than that, then it's likely false here. Now, that's what brings me to the next topic here, is that if you have been the victim of this, where, and a part of scamming is that the scammers do that. So they go ahead and tell you that they can get you your papers, just come work for them. And and it turns out that they cannot, or they didn't intend to, but they wanted you to work for them. That is trafficking by fraud. So that is labor trafficking by fraud. They willfully told you a lie, told you, came up with this ruse that and proposed it to you. And you, of course, thinking this is the employer, they're stand up people, they're going to do the right thing, they know the law. You went ahead and did what they asked. And you thought in exchange, you were going to get your papers. But instead, you find yourself trapped in a job where they have you right where they want you. So they are mistreating you. They are possibly even bringing up your immigration status. They're holding it over your head, saying, if the minute you want to quit, you want to leave, they start to say, oh, I thought you wanted the green card though. think about your children, think about yourself. If you don't stay and tough this out and get the work permit, then guess what's going to happen? Where are you going to go? So this is a form of labor trafficking, and that in itself qualifies you for relief here. It qualifies you for the T status as a victim of labor trafficking. And this is exactly what I help my clients with. And it has where you're here. You have any family. You don't have any means to get your papers. This is there for that. It is there to assist you with an impossible situation that you have been placed in because you were victimized. So if this is all sounding familiar, that's where it's time to give me a call. Let's talk about the situation, and I can confirm whether you qualify for relief based on the lie that you were told. Um, Now, the main thing here is that if you were told this lie, that they'll get you your papers in order for you to do something for them, to work for them, then that is a form of labor trafficking. Um, all right. So now that you know the answer, the general answer here to the question, you overstayed, can an employer now fix that situation for you and sponsor you? The general answer is no. It's likely not the case. However, there are a few exceptions here. If you qualify for, and keep in mind, just because the employer can't sponsor you doesn't mean you don't have other options. As I mentioned before, if that employer did that in a fraudulent manner, that could qualify you for the T status because they got you to work for them by fraud. And if you've had other experiences or situations, you could qualify for that. And I do explore those options in the consultation. So keep in mind that there may be options outside of an employer, but this is where you have to talk to me and we can go over that. Now, but when it comes to this employer, the employer knows you're out of status. The employer tells you you have to come work for them first before they can get your status. No, can't work. It's not going to work unless you qualify for an exception like Section 245I. And another one is where if you have a citizen or resident, spouse or parent who are here in the United States and they'll experience extreme hardship if you don't get the green card, then the employer can petition for you and then you can apply for that waiver. But the waiver doesn't allow you to stay here in the US. The waiver, what it does is it forgives the overstay. And when it comes to the interview, you can go to the interview, attend the interview, and that's where they will give you an immigrant visa to come back into the United States. So that is also another route. But then it's one of those situations where it really is dependent on the person's situation, because if you already had a citizen or resident parent, well, if you had a parent, that's a 5 to 7 year process. So clearly, doing it through the employer would be the best option. But if you had the spouse, that would be shorter than even the employer. And you trust your spouse. If you trust your spouse, you'll know then that you can see that process through with your spouse. So it's all about exploring your options here, but that is the general answer to that question that comes up very often. Now, I'm going to go through and just answer some questions very quickly. So put those questions in the comments now. Now, today's Wednesday. We have tomorrow and Friday. I'm handing out 4. So we have 4 more consultations to handle. We've already between Monday and today, we've already scheduled 6. I'm counting on 2 people have won already. I haven't checked yet, but I'm pretty sure 2 people have been scheduled already. So we have 6 people who now have free consultations, and we're handing out 4 more. So stay tuned. 12:30 tomorrow and Friday. I'll come on and do the same thing. I'll give you a code word. You call and give them the code word for the free consultation. All right, so let's get to questions, my favorite part. Um, I'm married to a green card holder. Can I get a green card too? So the green card holder can petition for you, but the way you're going to get it is it's going to be dependent on a number of factors. Are you here in the US? If you're here in the US, have they already filed your I-130 petition? Doesn't sound like it. But if they have, when is your priority date? If your priority date is on or before September 1st, 2023, and you have a current status here, meaning you didn't overstay, you have your papers here in the US, then it may be possible for you to then adjust status while being here to get the green card with your spouse. Say you're outside of the United States. Your green card holder spouse can petition for you as long as there are no disqualifying factors here. So that green card holder spouse can petition for you just like a US citizen would petition for their spouse. The difference, though, is that the US citizen spouse doesn't have to wait for the priority date to become current. The priority date is like a wait list. That's how I like to describe it. And when you are assigned a date, and you have to wait for that date to get to the top of the wait list for them to process your green card. As the spouse of a green card holder, unfortunately, there's that wait list sometimes. We just got the wait list back because there are more applicants than there are immigrant visa numbers to handle. With spouses of citizens, they don't have that limit. They don't have a wait list. So right now, it just depends. You can get your green card, but it depends on where are you and what's your current situation. If you came in the border and don't file your 1 year, is that a problem? Yes, it could be. So this is where I will often say, if you are intending to apply for asylum, you need to apply for it within 1 year of your entry. And it doesn't matter it doesn't matter whether you came by plane, boat, sea, air, through the border. You have to make sure that you meet that 1 year deadline. Now, you're not completely disqualified from asylum, but you do have to meet additional requirements. Now, once you miss the 1 year deadline for asylum, it means that now you have to either show that you face exceptional circumstances that led to the delay, or that you are facing changed circumstances in your country that now opens up the door for you to apply for asylum. For same category, can an individual with a later priority date be scheduled for an interview before an individual with an early your priority date? No, not usually, unless they bypass this because the case was expedited. That would be the only way I would see. And no, another thing is if there are complications in your case. So, say the both of your applications are being processed right now, but maybe there's a complication in the one with the earlier priority date, and so things have slowed down. Then the one with the later priority date will probably catch them up if their case is going more smoothly. So it just depends on what's going on once they start processing the application. Can a work sponsor if I haven't overstayed? Yes, it's possible. Now, you still have to think about timing. Timing of the application is going to be important, especially if you want to stay in the United States and get your green card at the same time. Because remember that an employer has to go through a Department of Labor certification process first, and that does not, you still have to maintain your status throughout the duration of that labor certification process. That can range anywhere from 6 months to up to 18 months. 18 months is if they have additional questions and they're really scrutinizing the application. And so if you're planning to stay here and get the green card, you cannot overstay during that period. Then when you get an approved labor certification, you're able to then have the employer petition and you do adjustment of status as long as you maintain your status. If you overstay, that's where the problem lies. You will be denied at that stage. Your petition may be approved, but your adjustment of status to stay here and get the green card is certainly going to be denied if you end up overstaying before you can file that adjustment of status application. So this is where timing is everything when it comes on to this employment-based green card. If you're, for example, if you're here on your visitor's visa, you say you have 6 months, your employer now wants to petition for you. You have to look at whether you can possibly maintain that visitor status until that labor certification is approved. If you can't, then you have to look at going back home and waiting out the process back at home and do it through the embassy. Even immigrant consultants giving this false info. Yes, because now you do have consultants that are certified by the Immigration Service to help with with immigration advice and documentation. But the problem is you have a bunch of people claiming to be immigration consultants, even when they haven't formally gone through any certification process. So you have to be very, very careful. When in doubt, make sure you go to a licensed attorney who can help you with the most complex issues. Even with an immigration consultant, sometimes they may not have the level of training, skill, knowledge that an attorney would have to solve your problems. So guys, make sure you invest in yourself because nobody else is going to care when everything goes into chaos for you. Oftentimes, I see where immigration people, so consultants, some call themselves paralegals, some even go as far as to calling themselves attorneys when they're not. They go ahead and file these papers, and some of them encourage immigrants to lie, to submit false paperwork. Some of them submit paperwork that the immigrant isn't aware of until later on. And when the immigrant gets into trouble for it, they are nowhere to be found. And guess what? Immigration is not trying to hear that either. There, you at the interview or when you are getting news that now they see fraud and misrepresentation, or you're denied because you don't qualify, and now it's too late, you've overstayed, you didn't realize all of this was going to happen. They're not going to sit down. That immigration officer is not going to sit down and listen to your explanation about who filled out your application for you and who gave you the advice, because they look at it as it is your responsibility to make sure that you choose the correct people to advise you. So invest in yourself, invest in your process, invest in your future. Don't take shortcuts by going with people who are gonna scam you and carry you down the wrong pathway. Can someone apply if their auntie is permanent resident? No, not directly through the aunt. Now, if you're under 21 and unmarried, the aunt sponsors your parent. You could be on the filing, and as long as you don't age out, you can get the permanent resident. So technically, that would be in getting the green card indirectly through your aunt because you are the child of your aunt's sister. For the same category, can an individual with a later priority date be scheduled? Okay, so I answered that. It just depends on what's going on in the cases. If you receive an ITIN number and you haven't overstayed as yet, are you able to go back to your country? Would you be flagged upon your return to the US? Having an ITIN number is not in of itself going to cause any immigration consequences because you have on a daily basis foreign nationals who do business in the United States and they don't have their social security number So what they do is they apply for the ITIN number to do conduct business in the US because yeah, business is it's global. It's a global affair now where we have businesses across borders. Individuals do businesses with individuals in the United States, and sometimes they do need these numbers to be able to carry all that business. So an ITIN is not in itself going to cause you to be red flagged. However, if you are traveling on a visa, a visitor's visa, and then you went ahead and used that ITIN to work, maybe you use that ITIN number for a number of transactions that indicate that you work. So maybe you opened a bank account, and then they deposited the money into your bank account, and maybe somewhere on the check it notes that your ITIN number. Then this can come back to bite you in the butt, and they could then find that you worked without a permit, or that you had the intention of staying here in the US because of what you did, the kind of things you did with the ITIN number. For another thing is that, say you are coming back in with your phone, and maybe you do some transactions with the ITIN number. Maybe you have it saved to your phone, and they do have the ability to search your phone when you're coming into the country. They can ask to search your phone, and they can pull, if they feel like it's justified, they can even pull information from your phone. And you would be surprised what they can see: bank accounts, information in your apps, pictures. So if they spot, say you took a picture of the card with the ITIN number, or you took a picture of your check because you wanted to deposit it into the bank, then that's gonna be a red flag, and they're gonna start definitely asking some questions. If it's not very clear you've been working, but now they see you have some number that you've been using for transactions, then that's gonna raise red flags. So it's not the ITIN number that it red flags you; it's what you do with the ITIN number. Um, Oh, awesome. So, thank you so much. Yes, I won my free consultation and I can't wait. My date is, oh, awesome. Thank you. I'm glad that you got that. And it's my pleasure. I can't wait to talk to you. If you do get married to a US citizen while you overstayed, what is the process to getting a green card? So, your U.S. citizen spouse, if they're fully involved in your process, everything is good, then you're going to apply. The spouse is going to apply for your petition, and at the same time, you're going to apply for adjustment of status. And while you wait, you can get the work permit, you can get the travel document to just, put you at ease while you wait for the green card. So that's going to be the process, and you should work on it ASAP so that you don't have too much lag time between the time you overstayed and the time you're able to work and move forward with your life. How to prove that a customary marriage in Nigeria has been dissolved to the immigration. So it's going to depend on what are the requirements to get a divorce in Nigeria. Now, you don't have to go back to if you got it dissolved in Nigeria, then you're either going to have to describe the process by which you got it dissolved. So say under the laws of Nigeria, you can do this verbally. I don't know if that's the case, but just say it's okay, it's acceptable, it's legally acceptable for the two spouses to say, I am separating from you, and you get divorced. Then in that case, you're going to have to show that Nigerian law does accept that type of divorce. So it's all about what is the process of getting the divorce in Nigeria, and then showing that this is a tradition, and then showing that you actually carried out this legally acceptable tradition to get divorced. Is it other way for a student visa holder get the green card instead of to apply for OPT? So no, definitely not go for that OPT. There's no direct path for a student to get their green card. So that's another thing, and I've seen such unfortunate situations where students think that they can get the green card directly, and so they skip the OPT. OPT is basically a way for you to get about a year. So it usually starts with a year of working, so you get authorized to work here for a year. So go for the OPT. Can't hurt for you to apply for OPT. Make sure you talk to your designated student officer about when it's the right time to apply for the OPT, so you don't miss the deadline. But go for the OPT. It can never hurt. Otherwise, if something goes awry with the green card, you're out of options. Can I be sponsored by a US family that want me to be part of their family? So they have to legally adopt you, and in order to legally adopt you, so they can't just want you to be a part of their family and then petition for you. I mean, you have, that's not how it works for the green card. You can't do that for the green card. But what you can do is, if you are under 16, or if the person is under 16, then the individual, the US citizen, can petition for them, can adopt them legally first, and it has to all happen before the age of 16. And then after, they can show that they've had full legal and physical custody of the person who is under 16 for 2 years, they can apply for to sponsor them for the green card. So adoption, it's tricky. And this is, by the way, adoption, if it's international adoption, you have to look at whether this is a Hague country, so it's under a special treaty. They have certain restrictions regarding adoption versus non-Hague country. So you also have to keep that in mind. If a parent submitted the I-130 for a child over 21 a few years ago but can't find the case number, how do you check to see if a visa is now ready? So you have to look at your priority date on the receipt notice and then go to the visa bulletin. So every month, they just released January's, and it is very disappointing, some of it, because right now where we didn't have wait lists, now we have wait lists again because there are so many applicants, outnumbering the number of visa numbers they have available. So now many of the categories have wait lists. Many of the categories have been pushed back, meaning delayed even further. So that's where you go. So you can go to Google, hit national, not national, but visa bulletin, and you can do January visa bulletin 2024, and you will see those dates. That you have to look at your priority date on the receipt notice, look at the date on the visa bulletin. If your date is before the date on the visa bulletin, it means that your number is current, and you should be hearing from them, like you should have heard from them. And you can tell when it's close, that number is close as well. So check it out. How long does it take NVC to send your welcome letter, siblings? So about 1 to 2 weeks. My son is 18. Will I be able to file for him at the same time when I submit? So if your son is 18, I don't know how you're doing. If you're doing it through marriage, then keep in mind that your spouse, who is the step parent, has to file for your son. Now, if you married the person before your son turned 18, then that step parent can file for them separately. They have to do it separately. They can't be on your application unless your spouse is a permanent resident. So get legal advice, because it just depends on what the situation is. How do I prove to the immigration that so I answered that. I came on late, so my employer wants a petition for me, but however, I overstayed my time. Is there a way that they can help me? It's unlikely. So overstaying usually puts puts a damper on the filing unless you qualify for an exception. How would you know if there is no interview? So they will give you some signs, like if they ask for the medical, they said send a request for evidence and say send your medical and nothing else. That's a big hint that they're gonna waive it. Can I apply for a work visa instead of green card? If I married a USC, my husband has some tax issues. Give me a call. It depends. What's your current status? You can apply for a work visa, but work visas are temporary, and you have to look at what your intentions are. What do you qualify for, and so forth. Can an employer petition for you if you overstayed? So that's exactly the title, and the general answer is no, unless you meet some exceptions here. All right, so I'm gonna come here so I can get through all. Thanks so much for your patience. I'm working through each platform, so I'm going to working my way around. So I'm gonna come to you, TikTok, in a minute. So next one, I'm going to YouTube. So type your questions in. May I ask, when I go to my interview, can I screenshot my welcome email so that it can be printed out? So now you usually, I don't know which interview. If you're talking about the interview at the embassy, they will send you an interview email. So you should go ahead and print that interview email, and that often serves as an interview letter if that's all you got. So you should not be screenshotting it. You should actually be printing all the email to make sure it's clear and that everything is printed as it should be. And they will not, by the way, don't go to the interview thinking you can just screenshot it on your phone and show security at the door. They won't accept that. They want to see paper unless they've instructed. Otherwise, unless they do have an electronic system in the country that they're from. But what I do is I print everything and I print it in order. So my client has a paper. How does the RFE for I-485 have something to do with your work permit waiting time, or after you do the biometrics adjustment of status with a citizen? So usually the processes are working parallel to each other. So while they're processing your I-485, they are processing your work permit at the same time. So it's sometimes you get the work permit before you even get the RFE for the I-485. So it doesn't necessarily mean that because you have an RFE, you won't get the work permit. My VAWA approved 10/10/23, and approval notice, my PD is 4/7/12. My wife is a green card holder when get the update. So if your priority date is 4/7/12, then you should be applying for adjustment of status now. So as for the status of the I-485, after approval, they start processing your I-485. They'll probably ask you for the medical, and then either schedule the interview or issue the green card. I'm married for 8 months now, and I need to put papers in. How can you help me? We can help you by preparing everything and representing you through the process. And we do have the legal experience to do that to avoid, potential mistakes. So give us a call and we can help you with that. Does the RFE for I-485? So I answered that. Interview scheduled with I-130 approved. What's the interview for? So I don't know what your situation is. So it would be hard to say, but maybe they just have some additional questions about the adjustment of status, or sometimes questions come up even after they've approved the I-130. So just make sure you're prepared. Make sure you get legal advice if you're in doubt. Do I qualify for 245I if my American parent was sponsored by his or her sibling? If it happened before April 30th, 2001, and you were a derivative on the application and your application was approvable, then it's a possibility that you could qualify for 245I. My green card has been pending for almost 3 years. On USCIS sent me a note saying I need an I-601, then definitely get legal advice and representation, because that means that they found an inadmissibility and they're telling you you need to get the waiver to get it pardoned before they can approve it. So this is where you need to make the move to fix that. A friend of mine came here off the ship. He's been here many years. His daughter's a citizen. Can he get his status changed without going back home? He needs to schedule an appointment. No, if he came off of the ship, then that means that he was working on the ship and came off. He came off on a crewman's visa. That's one of the worst visas to end up overstaying on, because the crewman's visa does not allow you to adjust status unless, of course, if you're in a situation like VAWA where you're being mistreated. So if he's being mistreated by his U.S. citizen or legal permanent resident spouse or citizen daughter who's age 21 or older, then in that case, adjustment of status may be possible. But otherwise, the crewmen, they do not allow people to overstay on the crewman's visa and adjust status. So this is where you need to talk to your attorney. If your attorney sent you an email that wasn't complete, talk to the attorney. Can you schedule a medical evaluation appointment from an immigration appointment doctor with an emailed welcome letter? So yes, no, you can use the emailed welcome letter and your DS-260 confirmation page as well. All right, so I'm going to just head now to TikTok, and we're going to answer the final questions here and then head out. How long does it take I-130? Okay, so the I-130 petition, if you're married, takes 9 to 12 months. So that's through the marriage-based process. Hey, I'm a Jamaican and I get married to an American. When is the best time to do the paperwork? So there's no rule that says you can't get started right now, but this is where it's very important to get legal advice about when is the right time for you to apply for it. I would like to talk to you. Go ahead, schedule that consultation. Go to the link in the profile. Click on that link, and you'll see a button that says, tells you to schedule your own appointment. It's really easy. How much time the working permit takes after filing asylum? 150 days after you've applied, you can apply for the work permit, and then they're authorized to issue it at 180 days, 6 months after you've applied for asylum. You have to make sure that you submit that work permit application. How my wife is being interviewed after approving the I-130, then they may have some additional questions. I just sent RFE medical for I-485, I-130 approved, marriage-based. What should I expect? You might see the green card in the mail. My husband has pending asylum case. I'm a US citizen. Can I sponsor my in-law because I am pregnant? So you can't sponsor your in-laws. Citizens can't sponsor their in-laws. Green card first before work. A nurse from Ghana, a pastor, wants to know more about this. So if you want more details, definitely schedule an appointment. But yes, so now what happens if that nurse is outside of the United States, she's being petitioned as a nurse to come here, that they should not be telling her to come here, work first, and then they'll get her the green card because she's outside of the country. She has to get the immigrant visa to come here and become a green card holder and then start to work. Now, if she's already here, she passed her test. Now she's looking at getting licensed, and they're saying, "All right, now just come work for us." Don't trust that because she should not be working until she at least gets the work permit through adjustment of status. How long to get green card once the I-130 and I-485 got approved? So it could range anywhere from a week to 4 weeks. If the I-130 petition is approved and they send an RFE for a medical, does that mean no interview? It could. How many months do I have to wait for working permit after marriage? So it could range anywhere from 3 to 6 months. How many months do I have to wait for working permit after the wedding? So you won't get it after the wedding. You have to get it after you apply for permanent residence. A foreign nurse on F2 visa has passed her NCLEX, and that's the nursing exam to, I believe, get licensed. Can she get the green card for herself and F1? It's unlikely she can get it for herself just based on being the nurse, but she can get an employer to petition for her if the employer agrees. And right now, I believe because there's a nurse shortage, they are waiving the labor certifications, but she has to get the employer to petition for her. When you apply for the T status, would you be able to still work with the employer? So this is a very difficult question, and it just depends. You may be in a situation where you're trapped and you're trying to find a way out, and the T status would be that way out. So I've had situations where my clients reach out for help because they're currently in the situation, and I explain to them what's the situation they're in and how to get out of it. And during the process of empowering themselves through T status, they escape. So the T status can help one escape, but you should not be planning to get the T status to continue working for an employer who's subjecting you to mistreatment, because that is not the point of T status. T status there is to empower you to escape the trafficking situation, or to recover here in the US from this trafficking situation that you were in. So keep that one in mind. All right. Thanks so much, everyone, for your time. I have to head out. I will be back tomorrow at 12:30 to hand out 2 more free consultations. So listen out for me then, look out for me then, and come with your questions. I'll answer your questions tomorrow. So thanks everyone for your time, for your questions. I appreciate it. All right. Bye-bye.